My name is Ed Lawwell. The date is July the 23rd, 1998. We are at the offices of the Tennessee Bar Foundation on 2nd Avenue in Nashville. We will be interviewing F. Evans Harville of Clarksville, Tennessee, as a part of the Tennessee Bar Foundation's Legal History Project. The interview will be videotaped and recorded audibly. This is one of a series of videotaped interviews which are being conducted of some of Tennessee's more prominent senior attorneys, the purpose of which is to preserve some of our legal history and heritage with the hopes that it will instill pride, character, and integrity of present and future lawyers of Tennessee, to the end that a greater degree of professionalism will be created. Evans, you and I have known each other for a number of years, and we will be discussing some of the topics today that you and I have talked about before. But first, I'd like to ask you a few questions to allow you to tell us about your family and personal background. I'll then ask you some questions to allow you to tell us about your long and distinguished career as an attorney. And then I would like to give you the opportunity to discuss your opinions about our legal profession today, what you think is right about it, what you think is wrong about it, and what you think that we as part of the organized bar might do to improve it. Okay?
Be fine, Ed.
First of all, let me ask you about your family background. I noticed that you were born in Las Casas in 1926.
That's correct, yeah. In fact, very few people know where Las Casas is.
Las Casas in Rutherford County.
In Rutherford County, center of the state of Tennessee.
Now, I also noticed that your father became a member of the faculty of Austin Peay University in 1929.
That's when the school opened, Ed. Dad was on the original faculty. It was really Austin Peay Normal School, a 2-year school for teachers' preparation. And Dad had been after Las Casas, where Dad was principal, he then went to Englewood up near Athens and was there for a couple of years. And then when Austin Peay opened, he never liked me to say it, but he had an uncle who was on State Board of Education, and Uncle Moody got him that job, but Dad denied it. But I knew good and well that Uncle Moody got it for him, and but he went on as a history professor, history teacher back in '29. So that was a great time for school to open, and opened in September of '29, and then 1 month later, we had the crash of '29, followed by the so-called depression until, not so-called, it was very real.
So I assume from that you moved to Clarksville when you were 3 years old.
3 years old.
Okay. Tell me a little bit about your father. Where did he grow up, and what was his education?
Dad was from Hickman County. He was the 7th child in a family of 13. He thought that gave him something special because he's a little superstitious on numbers. His dad was one of 18, so there are a lot of Harvilles have gone through Hickman County. Dad started teaching right out of high school. And then when World War I came on, he took a lot of pride in the fact that he was the first person from Hickman County to go in service. And when he came back, he went back into teaching. He got his BS from Middle Tennessee State Teachers College, it was then. And actually, he was on a baseball scholarship. And then I can remember, well, actually, he didn't get his degree until after I was born, because I was a babe in arms that went to his graduation. And then he got his master's at Peabody on the summers. And I can remember as a little kid, I'd go down and Mother and I would stay in Lewisburg at her parents' home while Dad was working off his master's at Peabody.
Okay, you mentioned your mother. Tell me about your mother. Where was she from?
She was from Marshall County, on the Mooresville Pike, out from between Lewisburg and Mooresville, on the way to your house, Ed.
Towards Columbia.
Towards Columbia there, and the home place had been in the family since 1822. Stayed in the family until early 90s when the family ran out and we finally had to sell it, which was one of the hardest things I had to do. And I dread seeing my uncle in the hereafter because he's going to really get on me for doing that.
What about you? Did your mother ever have any profession other than being a housewife?
She was a teacher. That's where she met my father. Dad was looking for teachers, and she had applied to teach at Lascassas, and he called, and actually her older sister answered the phone because mother had been out, I think, on a party, and didn't want to get up to talk, but she went over and she taught, and that's how they met, and they went together for about 3 years, and they married, and I came along. And
do you have any siblings?
no, I'm it.
Okay, the only child.
I'm in a unique situation. I'm an only child, married to an only child, with an only child.
Okay.
And I've told Peg that I think that's probably the reason we've gotten along. We hadn't anybody to mess with us.
All right. You mentioned Peg. Well, let's get her into the mix at the present time.
She got in the mix pretty early in my life.
Where was Peg from, and where did you meet her?
Peg was from Jordan, here in Davidson County. And in the summer of 1946, I was in my last quarter at Austin P before going to law school, and she had just gotten out of high school, and her mama was trying to fast track her for some reason. So she sent her down to Austin P, and we met that summer and went together for the next 4 years, my 3 years through law school and 1 year out, and we married in 1950.
Right. We'll return to your wife and daughter before we get through, but back to your childhood. I assume you grew up in Clarksville.
In Clarksville.
And your father was on the faculty
Right.
at Austin P, and then later became president.
Right. Dad went into the history teacher, as I said, and then sometime, a few years after we were there was a vacancy in the dean, so it may have been a consolidation, I don't know. He was dean registrar plus taught history, and then he coached the baseball team, and for a few years he coached both boys and girls basketball until they got a coach in. Times were hard.
Okay.
And I grew up in Clarksville, went to public schools. We had one grade school and one high school in the city, and we had a joint city-county high school, Old Clarksville High School, and finished that in 1942 at 16 years old.
Okay, very good. Before we leave your father, when did he become president of Austin P?
Well, Dad took a leave of absence from Austin P in 1942 and went back in service.
Okay.
And he served until 1946. Okay. And the president, Dr. Claxton, at that time was 86 years old. He'd been president for 16 years, and Dr. Claxton retired in the bloom of youth. And Dad became president in 46 and served 16 years and retired as president in 62.
Was that P.P. Claxton?
Yes, sir. Mm-hmm. Very distinguished gentleman, former United States Commissioner of Education.
Okay. I also know that after retiring from being president of Austin P, your dad had a distinguished career as a state senator.
Yeah, he laid out for 2 years, and then in '64 he got in the state senate race at 70 years old, and was elected and served 4 terms, 16 years, and his wife and I were the ones that really urged him just to quit while he was ahead, because I kept telling him, Dad, they remember you how you finish, and you sort of crowding it at 86.
Okay. All right. And your dad retired from the state senate at 86, and
Yes,
when
sir.
did he pass away?
He died at 91.
Okay. Now, your mother, I believe you've indicated that she died at a fairly early age, did she not?
Yes, so she died in 1954 at 51 years old, a victim of cancer.
Okay.
I was 28, and it really shook me, because my mother and I were real close.
Okay. All right. All right.
In fact, you never get over that.
Yes. All right. Let's talk about yourself a little bit. You went to public schools in Montgomery County.
Mm-hmm.
Went to Austin P College, which would be normal with your dad,
Right.
professor or president.
Well, actually, I was very fortunate. I never had to go to school, but about 4 or 5 weeks while Dad was on campus.
Okay.
I said he went in service the summer of '42, and I started Austin P the fall of '42. I worked the summer of '42 after getting out of high school at a clothing store for the august salary of $15 a week.
Okay. I believe you had some time in WW2, did you not?
Yes, sir. I went to Austin P, as I said, in '42, and I went to year round. So I was able to get 2 years of school in before I turned 18. And I had signed up in an Air Force program, pre-cadet program that they call you after you're 18, sign up for you 17 and a half. And in March of '44, I was called up and was sent to Keesler Field. And we were the next to the last group to qualify through classification that didn't get to go to pre-flight because they didn't have the losses at D-Day, thank God, that they had anticipated in the air. So they helped us as permanent party, froze for a while, and then after about a year they let us make rank. So I got 2 stripes, and then they had told us we were going to take the occupation since we'd really not done anything. Then the Air Corps changed and said, no, we signed you up for a special program, and since we can't put you in that special program, we'll give you an opportunity to go home. So
Okay.
they called it for the convenience of the government. It was convenience of me more than the government.
For the benefit of some of our younger audience, of course, I refer to WW2 as World War II.
Yeah.
All of us older people certainly realize that. All right, then you finished your college after you got out of service.
Well, yeah, I got out of service and went back to the P in the winter quarter, spring quarter, and summer quarter. That gave me 3 years. And Vanderbilt Law School had been closed down during the war, and they announced they're going to reopen the fall of '46. And it was open, if you were a veteran and had 2 years, you could get admitted, or if you had a BS degree, or if you had 3 years leading towards a BS degree. So I qualified on 2 categories, and so I applied and got accepted. Now, one thing, that was before you had LSAT,
Okay.
and it was a first come, first serve. I sent in a letter with a transcript that wasn't all that great, and got acceptance almost by return mail. And it was just whoever, and sometimes I think it was better because we had a pretty distinguished class. Mr. Justice Cooper, Charlie Warfield, General Milton Rice, Cecil Brandstetter. I mean, just to name a few.
How about Judge Harbison?
Judge Harbison was 1 year, he was in the class of 50, I was in the class of 49.
Let me ask you a minute, we'll get back to your law school.
But I knew Bill quite well.
Okay. We'll get back to law school in a minute, but let me ask you some of the influences that caused you to go into the legal profession.
Well, Ed, I was just sort of thought I would. People said I was pretty mouthy and argued a lot and would make a good lawyer because I was hard-headed. And really on these classification tests, aptitude tests you take in high school, it showed law and government as where I would score the highest. And sometimes I said I was a lawyer by default. I didn't know anything else I could do, so weed the rest of it out.
The fact that your father was an educator and you had grown up in academic circles, did that play any part in it?
I don't think so. Other than the fact, I think Dad would have loved to have gone to law school. I think had you had a GI Bill after World War I, like we had after World War II, he would have probably used it to go to law school.
Okay. Tell me about the law school at Vanderbilt, just opened up after World War II. Who were some of the professors there that you recall?
Well, your dean was Dean Kaufman, L. Dale Kaufman. Sometimes we called him Lord Dale. He had a nice habit of standing on, he taught torts. He'd stand on that little podium and he would open up his vest and let his Phi Beta Kappa key dangle. And he would bounce, and he told us a story. He was a Harvard man. He told us the difference one day, that the difference between a student at Harvard and a student at UVA was when the professor came in at the University of Virginia and said, "Good morning, students." The student said, "Good morning, professor." Said at Harvard, when the professor came in and said, "Good morning, students," they wrote it down. Dean Kaufman went on to be dean at Pepperdine No, he went to UCLA and
Okay.
he went from Vanderbilt to UCLA Law School and took a substantial portion of the faculty with him. But he left the year that I graduated, so our faculty pretty well was the same all the way through. We had a man named Jefferson Fordham who went on, and he was later the dean of the University of Pennsylvania. Had a man named Hugh Swords, who was a Yale graduate, who the word says that when he took his Connecticut bar, he cited a case or a statute for every proposition of law. You were the only other person I know that ever did that, Ed. He went on and was a professor, distinguished professor at the University of Miami.
Okay.
A great property professor named Mr. Verrill, Roland Perkins, criminal and bills and notes, as we called it. He was on the committee that wrote the new commercial code, as we called it. When he taught that course, he wanted to know what the law merchant was, what the NIL was, and negotiable instrument law and then what it would be on the new commercial code. So it was, and he'd cite them by, you'd ask him a question, he'd say, well, have you read section so-and-so? No, sir, I don't know whether I have or not, but he had the thing, he was just a brilliant gentleman. I felt I had an excellent faculty.
You have named some of the well-known classmates of yours here today. I take it that the law school was in the third and fourth floor of Kirkland Hall.
That's correct.
Right? And this was before Dean Wade came.
Oh yeah, Dean Wade came last year.
Okay.
And he came from University of Ole Miss. And Dean Wade came. He'd been an oil and gas professor. And they put him teaching a course in administrative law, which Dean Kaufman decided everybody had to take. And Dean Wade, the first day in class, he says, "Young gentlemen, if I had my choice to list each course that I would teach in order of preference, I assure you this would be at the bottom of the list. But you must put up with me, and I will put up with you."
Okay.
Now, I have mocked him to his son, and he knows that I do that with a lot of affection for Dean Wade, because there's no one for whom I have a greater respect and greater regard.
How many was in your class?
I think there was 125 that graduated.
Okay. So it was a large class.
Yes, we had that. If you went to Vanderbilt,
Right.
And if you at Kirkland,
Yes.
when you get on that top floor, that full lecture hall, the first year we filled that lecture hall.
Right. Very good.
In one section, just one section to fill that lecture hall.
Were they all men?
We had two women. One of them was Catherine Cooper. She came over. She came over to. She was Bob Cooper's girlfriend, later his wife, and Kitty came over. And she and there was one other girl. There were two women in the law school.
Okay. All right.
Another character I'd like to mention. He's now just recently deceased, but you may have known Huddy Alexander from Franklin. Huddy had been a polio victim as a kid. His father had written about him as the littlest little boy, and he had heavy braces on his legs from his hip down. Huddy, every day, climbed those steps with those law books. We would offer to help him carry his books. He never took any help from anybody. He went up those steps. I don't know any young man in our class who was more admired than the courage that he showed.
Okay.
One other thing, too, about Catherine Kelly, later married Judge Cooper, we all got in the habit of calling her Miss Kelly. Miss Kelly. And after they were married and Bob was on the Supreme Court, we'd be out and I'd say, "Hello, Judge Cooper, how are you, Miss Kelly?" And he says, "Evans, for goodness sake, people will think we're not married." But all of his classmates would always refer to Kitty as Miss Kelly.
Okay. Okay. Even though you spent a couple of years in service, because you had gotten out of high school at 16, you were able to graduate from law school at age 20 or 21?
23.
23.
Uh-huh.
All right. Did you know what you were going to do as a career while you were in law school?
No, sir. One thing let me mention, Ed, I think it shows the different time. At the time, the GI Bill would pay our books, fees, and tuition up to a maximum of $500 a year. Not no time, including the year when I graduated, they paid for the cap and gown rental and bought you a certificate of graduation, did they ever use the full $500. And now you contrast that to what's the tuition out there now, 20?
22, I believe.
And one great advantage, when I got out of law school, I didn't know what I was going to do. I didn't know where I was going. But I had one advantage. I didn't owe a dime. The government had paid that, and that $75 a month subsistence, which they paid us single people, covered, and I was having a nice social life every month except the 1 month when I had to pay my room rent. So my folks would help me with my room rent.
Okay, you did have a room in Nashville.
I stayed in Old Wesley Hall.
Okay.
Across 21st.
Okay.
That was a great mix. They had us in there in the School of Religion.
Okay. All right. Now,
I won't go into that.
let's talk about your professional life a little bit now. The transition between law school and your professional life. In those days, could you take the bar exam before you graduated from law school?
Yeah, we were next to the last class that could do that. My second year in school, the Supreme Court changed the rule. Said you had to have your law degree. But they grandfathered those of us in that were in school. So at the end of 1948, we all took the bar. We did not have any Crossley cram courses, that sort of stuff. And I can remember that I sort of closeted myself with my notebooks and what advance sheets I could find, and studied cram for the bar, except on weekends. Had to play a little bit, and we took the bar, and we had a fantastic success rate. One interesting story along that, Ed. When we got back in school, there was one boy who was a good student. He's a better student than a lot of, but he had gotten bad news from the bar.
Okay.
And he was sort of down, and we were talking with him and said, look, why don't you call Judge Albert Williams? He's got a wonderful reputation of being very sympathetic to law students and young lawyers, and he was on the bar. He was a bar examiner that monitored the test in when we took it in Nashville, and see where you missed it. No, I won't do that. Well, we kept after him. So finally he did call and make an appointment with Judge Williams. And Judge Williams graciously saw him as we knew he would, and he had his papers, and he was sitting there with the boy, and he said, well, young man, you did exceedingly well on the first section. Because we took 4 sessions, all written. We didn't have the multi-state.
All essay.
And it was all essay, and you had to total 300 points off those 4 sessions, average 75. And he said, well, you did extremely well on the second section. You did well on the third section. So, son, you passed the bar. We just failed to add in one of those 4 sessions.
You kidding?
He said, congratulations. I want to be the first one to congratulate you. And that boy came into class the next morning. He was walking on air.
I can imagine.
And we were all just delighted because in those days, that was not the competition among law students. It was sort of a grace of God and long-handled spoon. We'll all survive together.
Judge Williams was still on the Board of Law Examiners when I came through, and it might be of interest to know that he was a senior partner of Miss Rebecca Thomas.
I knew that. I knew that. And I knew Rebecca just loved him dearly, and with justification. He was a wonderful gentleman.
Right.
But this young man, I mean, we all just really, really cheered.
Okay. Well, that is great.
And one other interesting story I thought to me, that fall, Dean Kaufman took us all before the court to be introduced and enrolled in the court. And he said, now we have here so many young men who have successfully taken and passed the bar in 1948. And we have one man who has successfully passed the bar in 1908. And Judge Neal, who's then Chief Justice, says, Dean, would you have that man who passed the bar in 1908 step forward? His license predate mine. What it was, a gentleman named Mr. Godby had gone and finished and had gone to Vanderbilt Law School, had not been able to graduate, but had passed the bar. He had always wanted to get his degree. He got drafted from the state of Florida at 58 years old, which we still don't know how that happened. Served in the Pacific, and he was ready to retire when he got out of the Army, and so he had the GI Bill, so he went back to Vanderbilt Law School as a first-year law student, went right through with all of us.
Well, that's interesting.
Put the little freshman beanie cap on and everything else. He was really a joy and a delight.
Okay.
But that was out of my group that went before the court and were enrolled. One man's license had his license for 40 years.
Okay. So you graduated in 1948 and already had your
graduated in 49.
49.
Had my license in 48.
Already had your license. All right. What did you do about beginning your career of practicing there?
Well, I'd always said I was never going to go to Clarksville, but I did.
Okay.
I had talked to several lawyers about vacancies. They weren't recruiting like they did in those days. A man named Billy Daniel, who was 10 years my elder, whose father and grandfather had both practiced in law, and his uncle had practiced in Clarksville. And Billy had he'd been licensed in 38, and he had lost about 4 years in the Air Corps during World War II, but he was back I had an office, and I'd been by to see Billy, Mr. Daniel as I called him at that time, and he was very non-committal. And then I was looking around trying to find a place just to put out a shingle, and didn't know what I was going to do.
Now, were you married then?
No, sir.
Okay. All right.
Billy called me, and he said, "I want to see you again, boy." So I said, "Yes, sir." I went up there. He said, "Now, that vacant office there, you can have, and I won't charge you any rent." I thought, this sounds pretty good. And he says, "My secretary will do your work when she's not busy on mine, but that's not going to be too often. Anybody who comes in and asks for a lawyer or asks for me is mine. If they come and ask for you, it can be yours. I would expect you to help me on anything that I need you to work on when you're not busy on your own stuff, and that's going to be most of the time." And he said, "And there's one other thing you need to remember. Those steps you came up," his office up over a drugstore, "and that hall you came down runs both ways. And if either one of us get the least bit dissatisfied, you're going to be one to hit that hall, hit those steps, and the only advice I'll give you is don't let that door hit you in the butt as you go out."
Okay. All right.
And I said, "Golly, Mr. Daniel, that sounds like a great deal to me." We shook hands, and then 32 years later, he retired.
Okay. And you had no salary whatsoever?
No salary whatsoever.
Okay.
But I learned an awful lot. Billy at that time had going representing a lender who was doing about the only subdivision we had going in Clarksville at that time, with VA and FHA loans, and also he had a good insurance defense practice. So I got the opportunity to go out and do a lot of insurance investigation, and would come back and go over the statements I'd taken, and he was very patient, say, "Boy, you missed this, you missed that, and missed the other," and then learn a lot of real estate with him at that time. And then another thing that's quite interesting, the summer that first summer I was with Billy, a major building in town fell, just collapsed. The old Masonic Temple building. There was a photograph taken of it that made Life magazine, and it was a rather complex piece of litigation, but a wrongful death case followed, and we represented one of the contractors involved in it. And I can remember that summer being in the basement of that building that had fallen and walking over those old limestone foundation blocks that had kicked in and such as that. And my mother got upset when I went home, told her where I'd been, but it was all right. And we tried that. We lost it at the trial level. We lost the Court of Appeals, but we got out at the Supreme Court on a license technicality. And I can remember those days you had the time, so every afternoon about 3 o'clock, Billy and I would sit and we would discuss aspects of that case. Our client had taken the contract as an accommodation to an unlicensed contractor, and he'd assigned the job to him, and he was in only because of that assignment. And we found a case, I'll never forget it. In fact, I stumbled upon it. I remember the style to this day, Morey versus Black, which was a driver's license, which said that the owner of a car who loans a car to an unlicensed driver who is otherwise competent is not liable. And we cited that when we sought cert, and Justice Neal, in granting cert, said that Morey versus Black did control in this instance, and since there was no proof that the assignee contractor was not competent, proof was that he was competent. It was just that technicality, being unlicensed, that case would be. And it's right strange, but after all these years, I remember the style of that case, and I remember the euphoric feeling when I found a case. I said, Billy, this might float.
Okay, that's great. Obviously, your relationship with Billy Daniel worked out pretty good to your advantage.
It was great, very great. The following year, we created a partnership, and it was I had a percentage, and it still wasn't the most affluent thing. We had a great financial system, though. We kept a backlog of $500. But every time we get $500 above that, we divide it.
Okay.
So that may not sound like much this day and age, but it wasn't the law practice. You expected a starvation period.
Okay.
And quite frankly, I think the lawyers of today would be better off if they knew and expected a little bit of a struggle to build. You'd appreciate what you had more.
Do you recall how much you made your first year of practice?
It wasn't much. I do recall this much. It wasn't enough where if I had been married, the split income would have helped me, and you had to make $3,200 in.
Okay.
And that included the $1,200 that I made for the 12 months of teaching, $100 a month teaching night school.
Okay. You were teaching at night school?
Teaching night school. We had a world of ex-GIs, and the 11th Airborne had come back to Campbell, a lot of young lieutenants who wanted to get the education, so they would come in night school. So I taught night school.
At Austin P?
Uh-huh.
Okay.
Taught business, taught business law, and taught a little history, taught a little college algebra, and different things. But it was fun. I enjoyed that. Met some great people, and that was a great opportunity for me to get to know people. People get to know me, and got a world of folks who came to me as clients just as a result of that.
Okay. All right. we know that your career did progress in Clarksville. You did become a prominent attorney, and in your firm.
Main reason I'm prominent, I've outlived the rest of them.
Okay. The number increased, but how long did you and Billy Daniel practice by yourself?
As Billy and I were together from 1949 till I think 1956 or 57 when Dick Batson joined us.
All right. What were the primary areas of law that you were involved in most?
At that time, we would, as I said, Billy had represented a number of insurance companies, insurance defense work, and he represented the Northern Bank. And then in '54, Billy and I created First Federal, Billy primarily, but we created with attorneys for creating the First Federal Savings and Loan Association. So we had those two institutions plus insurance defense work, and then general people practice. And as time went on, we sort of divided up, and Billy and I took the banking and estate work and the real estate work, and some of the people practice, and Dick Batson and Dan Nolan, Dan who joined us, Dan joined us about 31 years ago, which would have been about 67. When he joined us about 67, he and Dick primarily went to the insurance defense work, and I graduated and gradually got out of it.
Okay. What did you've told us a couple of cases already. Do you remember anything else?
I had one real interesting case that it was the ugliest divorce case I ever had in my life, and I don't try not to have them. But this particular case represented the wife of, and they had one small boy who was about the same age as my daughter, about 3 or 4 years old. and 5, and we had to have restraining orders in the whole 9 yards. In fact, it was so bad that it was the only time that Chancellor Leach ever refused to give a father visitation privileges. But we couldn't get him served. They were renting an old house. That time the officers could not break the outer doors, but they could break the inner doors to serve process. And he got in the house and got the doors locked. We were there, had a great big double jointed deputy, about 6'5" and about 220, but Jim wouldn't break the outer door, so my client's brother climbed up, went through an open window, came down and opened the door. Well, the defendant knew we were in the building, so he went and jumped in the bathtub, filled the bathtub up with water, and was sitting in the bathtub in his all together, and the deputy forced the door open, and the man sitting there in his all together stuck his fingers in his ears when the deputy went to read it to him, and then he laid it in the tub to him. I never seen, first time I ever seen a man served in the altogether like that. Okay. Then in the trial of the lawsuit, it was before Chancellor Leach, and I was cross-examining him, and all of a sudden he stopped and he said, "Okay, you win, you can have her." I said, "Do what?" He said, "You told me when we got started you would do everything in your power to get my wife a divorce from me." I said, "Now I know why. You want her for yourself. Okay, you can have her. I'll give her to you." I turned to the court. I said, "Your Honor, my client, I admit, is a lovely lady, but I got more than I can say grace over and over." And if you remember Chancellor Leach, I think you had the privilege of practicing in front of him, he turned around and he scalded that fellow. He says, because one thing he would not tolerate was anybody abusing counsel if counsel was behaving themselves. If anybody going to get on him, he'd go get on him.
Yeah. I had the utmost respect for Judge Leach.
Oh, he's one of the truly great men I've been privileged to know.
Right. A friend of mine, a friend of yours the other day, told us about a particular case that where the doctrine of the last clear chance came into.
That wouldn't have been Sam Bowes, would it?
Well, I thought you might want to tell us about that case.
Well,
I believe it was a General Sessions Court case.
Yeah, it was. It was. Sam, who later went on to be Judge Bowes,
right.
Was practicing, and Billy Beach was our General Sessions judge. Billy went on. That was the last case he was tried as Sessions judge. He was going back into private practice, and we were over there. And incidentally, Billy went on to have a very distinguished career as our county executive. But anyway, we were trying this case, and it happened down the south end of the county, and I was defending. Sam's client had backed out of the driveway on a roly-poly hilly land over south of the river that goes, and the car, while he was trying to get it straight up in the road, my client popped over that hill and creamed him. And when Sam was making his opening statement, he smiled, and he looked at Judge Beach, and Bowes was a very dignified gentleman, and he was a lawyer and an excellent judge when he was on the bench. But he was talking. "I would like to cite, Your Honor, to the old Queen's Bench case of," he called a style, I don't remember it. He says, "In that case, this Englishman had his tethered ass in the highway, and the defendant, driving his wagon and teams in a reckless fashion, came upon, struck, and injured the plaintiff's tethered ass in the highway. And the Queen's Bench held that he could recover." And when I came to respond, I said, "I'm not overly familiar with the case that Mr. Bowes has cited about the Old English case, but I said, I would like to point out to the court that was the days of animal power, not high-speed locomotion like we have today. And looking at the short interval from the crest of that hill to where this vehicle was pulled out and blocking the road, I'm convinced that had that case come up today, that that same Queen's Bench court would have held that Mr. Bose's Englishman should have got his ass out of the road. And then I turned around and went to sit down, and Collier Goodman Jr. was, I said, Collier, what'd Billy do? He said, he's halfway over the bench after you. And when it was over with, Billy held with me. After it was over, he said, "You've never done it. You've never done it. You've never said it. If you hadn't known I was as my last case, if you know, you shouldn't have done that." I said, "Billy, I didn't say anything improper." He said, "No, but Sam has never gotten over that."
Well, that would be the doctor's last clear chance.
That would be what he'd been referring to. Sam still remembers that. He said, "You really nailed me on that."
Okay. All right.
Let me interrupt just a minute. Your microphone has just slipped off your tie. If we can just get it back in place there, we'll just continue on. I'll leave the camera recording. I think it got wrapped up in your foot. Maybe it got
Okay.
That's good.
Thank you.
Okay. Okay. Let's sort of summarize your practice. It is 50 years.
Mm-hmm. Well, actually 49. I've been licensed 50,
Right,
but practiced
okay.
50.
50 years.
I got the old folks certificate at the last convention.
Mostly civil practice.
Yeah, I tried a few criminal cases at the start, but I tell folks I have not tried a criminal case since Earl Warren took the federal bench, so I'd be dangerous in the criminal courtroom.
Okay. And mostly in the Clarksville area.
Uh-huh. I've been Ed, I've got a number of good friends who are excellent lawyers who seem to enjoy the fact that they can travel all over the country. They try a case in San Francisco and in Los Angeles and Pittsburgh and all over. And I think I've been very blessed. I've been able to make a living in Montgomery County and get to go home every night and sleep in the same bed with the same woman. I think there's great advantages in that.
Right. But anyway, you're not completely through yet. You at least changed gears.
Changed gears. I did not want to work hard enough to be a full partner, and so in January a year ago, I sold out my proprietary interest in the old firm, and things just didn't work out as far as staying off counsel there. So I'm now counsel in another firm with 5 young men. Oldest of whom is Rudolph Ross and Finley, the name of the firm, and Jack is the oldest member. I think he's about 46 or 47 years old, and it's really energizing. I have been there with them almost a year now, and I come and go. I work on what I want to. I'm off counsel. I don't have any of their administrative responsibilities. I have full secretarial help. I've been very blessed. A large number of my clients have come with me, and I'm able to continue my practice in the areas that I want to practice. If I don't want to fool with it, I say, I'm sorry, I'm not handling that. If somebody else in the firm wants to handle it, I'll refer it to them. Otherwise, I'll help them. If it's accommodating a friend, I can take time off and do that. I don't have to worry about that damnable billable hour.
Okay.
And if you want to get into that, I can make you a speech on that.
We'll discuss that a little later.
But I'm really enjoying where I am now, and I've had friends tell me that you really look like a different person.
Okay. But anyway, even though you're not at the end, you're getting toward the end of your career.
I'm in the last half.
Right, and from what I've known you, I would say that it has been very successful and very satisfying to you, and I just wanted to know if you'd like to summarize your overall opinion of what you got to think about your legal career up to this point.
Ed, I've said this many times, like anybody else, we'd all like to be a little bit younger. But I would not take anything in the world for having grown up during the 30s and the 40s. My generation was a blessed generation. We didn't have but 2 problems, the Depression and World War II, but they were both identifiable. These kids today have got so much pressure, so much, and I think there was not the peer pressure. There was not the keeping up with the Joneses to the full extent there is today. My generation and I today don't mind saying I'm sorry, I can't afford it. For example, I got out of law school in 49, I got married in the summer of 50, and I bought my first automobile in February of 53. We lived in an apartment. Many nights, Peg and I sat in the middle of the floor and played cribbage because we didn't have the money to go out. I may have mentioned that, I don't know. But the kids today, they want to come out, they want to start out the way Daddy and Mama spent a lifetime ending up. I don't begrudge them that, but I think you appreciate things more if you have to hunt for it. The lawyers at the time that I came up, there was much more congeniality. There was much more you liked each other. We had a regular bar party, and it was really fun. We'd have a couple of drinks, and we'd play a little cards, and we'd stay out and have a real fine party. Invite the lawyers from all around the surrounding circuit. Lawyers don't seem to like each other that much. They look on as competitors. In Clarksville, we knew who was whose client. You respected those people's client. You didn't try to steal them. You wouldn't go to that so-and-so's client. You'd call up and Mr. Goodlett Sr., for example, say, I need to talk to so-and-so about such and such. You got any problem with it? No, you go ahead, or Evans, what do you want? I'll get it for you. I mean, that type of cooperation, if it's something you were getting into and you weren't familiar with, you could call one of the older lawyers and say, I keep referring to Mr. Collier Goodlett Sr. because he was really a mentor. I loved him dearly. Or Mr. Hubert Porter, and say, I've got a problem. They'd say, well, give me about 30 minutes. Come over. They'd sit down. I trusted them. They trusted me. My friend Wally Rassus, who's now fully retired, Wally was always very, very gracious. In fact, the first lawsuit I tried with Wally. He called me up and he says, you're closer to the law school than I am. You probably know more about this. So I got to try a case in Chancery Court that I wouldn't have had otherwise. The lawyers cooperate. The lawyers trusted each other more.
What about, I don't know in Clarksville, but I've experienced this in Columbia, and I would imagine you had the same experience. What about when a general practitioner, our sole practitioner died, about the other lawyers winding up his business for him and being able to finish up what he had going?
Yeah. They'd help it out. And along that same line, when a lawyer friend of mine, I won't call his name for privacy to him, he lost his wife in a car accident. And he had a major piece of work to be done. And he came over for a major client, regular client. He came over and asked us, says, would you help me on it? I don't feel competent to do it because it was an emotional situation. We took the work, we did the work, we gave it back to him. We let him furnish it to the client. We didn't make any move to try to steal his client in any way. They don't do that anymore.
Right.
It's become a business. It's become a business.
Okay.
I read, I'm going to paraphrase, but Henry Dinker of the Philadelphia Bar was father of modern day legal ethics. And he was quoted an opinion by Joe Henry, and this is not an exact quote, of what a professional, being a professional, where the service to the client is paramount, and the emolument of the office is a byproduct thereof.
Yes. Yes.
And I agree with that. Now it's a business. It's marketed like a business. A profession can't. There's a business aspect to a profession, but you can't be both business and profession.
Okay. Okay.
In my opinion.
Yeah.
Now there are a lot of lawyers out there going to disagree with that statement.
Yeah. I want to get back and wind up some of your thoughts in that area, but there's a couple of other things I need to cover. First of all, your family. We sort of put Peg down. Peg has been your lifelong partner, and she's never been gainfully employed, but she does have an avocation. Does she?
Yes, sir. as I said, I met Peg when she was 16 and I was 20, and I caught her young before she really knew a whole lot better, and was able to talk into marrying me after 4 years, and we've been married since 1950, and we've got a real great situation.
Yes. By the way, her full name is, what was her maiden name?
Douglas, Peggy Douglas,
Okay.
from up in Jolton community.
She does some artist work, does she not?
Yeah, we have one daughter who was born in '58, and when Kitty went off to college in 1976.
Kitty's your daughter now?
Kitty's my daughter. When she's named for my mother. My mother was Catherine, and her name is Catherine Evans Harville, and we call her Kitty. When Kitty went off to college in '76, Peg had prepared for the empty nest syndrome. I hadn't. And she went back over to Austin Peay. She had a BS in home ec, but she knew she wanted to go into art. And she started taking art courses. She didn't know what she wanted to do, but she knew that was an itch she had to scratch. And so she took courses off and on over there for over 10 years. And watercolor became her medium. And she's had a lot of real success. She's had paintings submitted to it, accepted in national shows. She's had 2 in the Rocky Mountain show, which is the second largest show in the nation, second only to American Watercolor. She's been accepted in Kentucky on more than one occasion, traveling shows, Tennessee Watercolor Society, purchase awards from Evansville, has Evansville, Indiana, been in show, had a purchase, I think, in New Orleans show, and been in Alabama show. So she's had a real successful career in her watercolor.
And your daughter has sort of followed in her footsteps.
Yeah, Kitty went off to SMU, and she thought she was going to be a theater major, but the first fall during football season, when all of her friends were going out to the ball games and the parties, she was supposed to be building sets, and she saw about 3 years before she got on stage. So she said that's too much, and so she changed over to art, which was where she belonged.
Okay.
And she got a BFA from SMU. Then she was in Chicago. She took a master's in art therapy from Circle Campus, Illinois, University of Illinois Circle. And then she, in order to market their skills, she went to a trade school on Michigan Avenue. So she got a BS, BFA, a master's, and then a AA. Did it backwards, but that's taken after her daddy, I guess.
And she has been able to use it.
Yes, sir. She is in Little Rock, and she and another person have a creative design firm.
Okay.
And Charlie does all the computer stuff, and Kitty does the fine art.
Okay.
And she's been able to illustrate 4 children's books. That's what she really enjoys doing. Had been out and marketing. One of them is in a reprint. One of them was the 1996 Booksellers Pick of the Year, which was, she's real proud of that book.
Okay. Now, I'd like to discuss with you your work in the, say, extracurricular activities of the legal profession. I know you've been active in the Tennessee Bar Association, the American Bar Association. Tell me, first of all, for the Tennessee Bar Association, what's been your primary jobs and functions that you have performed?
Well, the first thing that got me started at the Tennessee Bar, in 1970, the bar used to charter a plane and take these nice trips, and I never had gone on one. 1972, I believe it was, came out in the bar paper, publication, that Frank Ratton, who was wrapping up his year, was going to take a group to Rome. So I went home and told Peg, I said, Peg, we're going to go to Rome. She said, Georgia? I said, hell no. Italy. Make a long story short, we signed up and went on that trip, and it was a delightful trip. I got to know a world of people. Graham Bartlett from Knoxville was one that we developed a fast friendship. Harlan Dodson. Harlan was moving vice president, we called it that time. Walter Armstrong was president-elect. Bud Seymour from Knoxville. It was just a great bunch of people. Judge Morton was on there. I had a chance to see Judge Morton off the bench, and not in a robe, and he and Marge are delightful people to sit around and eat an Italian meal with. And that I got interested in the bar from that standpoint, sort of backed into it. And then I went the next year on the trip to Spain, which Walter took us. And then when Dodson was going in, no one had qualified to run for vice president from Middle Tennessee. And Harlan called me up and said, Evans, I've got a vacancy. And of course, it's pretty well president's prerogative to fill those slots. And would you take it? And I felt highly honored. I commented to somebody, I said, well, I'm fixing to be vice president of Tennessee Bar and never been to a convention. That's not, but that got me started. I give Harlan Dodson full credit for getting me started and getting interested in serving on his board and seeing what was going on. And Billy Bethel was a great friend to me and very knowledgeable in bar work. And then I laid out a year. Then I think I ran for the Board of Governors. And make a long story short, when it rolled around to rural Middle Tennessee, I got in there moving vice president and was privileged to serve in 79, 80 as bar president. It was a great experience,
Actually, the way it's set up, the rural Middle Tennessee members can only have a president every 9 years.
That's correct.
Right.
See, what you do, it rotates Middle, East, and West, and then one out of every three in Middle comes out of Nashville.
Right. Okay.
But I was fortunate at that time. Prior to that, I had gotten on the Board of Professional Responsibility.
I was going to ask you about that.
78 to 83. So being a glutton for punishment, was on that board at the same time I was bar president, which was an agony and an ecstasy, but it was a real ecstasy because it gave me an opportunity, sitting two ways, to get what I consider the best contribution I've made for the lawyer. During my bar year, we got the Supreme Court to amend the rules, setting forth formal and informal ethical opinions. Okay. And working with the board, I could have a foot in that world. And then from the Bar Association standpoint, and we were told that when we started with that the court was not interested in doing that. But fortunately, God love him, Joe Henry was. And if you knew Joe Henry, and I know you did, Ed, Joe was the irresistible force when Joe got to moving. So I give Joe Henry a world of credit for helping us sell that. And I think that's turned out to be a great thing for young lawyers, all lawyers, to be able to get that ethical hotline, to get that formal ethical opinion, get that informal ethical opinion, because it does give you an area of protection. And it's getting so complex now. You need that. You need that.
I noticed on your resume that you said a special Supreme Court judge at one time. Tell us what that was about.
Well, back in, I think it was 76, and the legislature had come in and it had changed the retirement for judges, how it was going to work. And there's a question of whether or not they could make that retroactive. And litigation came. Judge Miles, who was circuit judge here in Nashville, brought a class action, and it went to the Supreme Court. And the whole Supreme Court recused itself, naturally. And I was blessed to get the opportunity to sit on that. Bill Willis was Chief Justice, and who is an excellent friend of mine, an excellent lawyer. I'm sure you know him. And Charlie Gore from Bristol, who's now deceased. A man named Stevens from Memphis, and a Winningham boy, gentleman from Chattanooga. And the five of us had the privilege of hearing that argued, and it was very ably argued. Val Sanford,
Okay.
who was, incidentally speaking of distinguished classmates, Val was a classmate of mine also, was on one side, and the Honorable Tom Wiseman was the advocate on the other side. And you talk about a well-argued, well-presented by two real pros.
Okay. So was that the only case you ever sat on?
Only case we ever sat on.
Did you ever have any aspiration to become a judge?
One time, but I think I'm happier where I was.
Okay. Okay.
I think I'm happier. I think I toyed with the idea back in about 76. Our Chancellor, Bill Hall, from Dixon, was killed in a car wreck. And at that time, my father was in the state senate, and I thought long and loud about whether or not I would want to seek that chancellor slot, because that's the only bench that I would really be interested in. And I had already made a mental determination that I was going to get in the chairs and seek to be bar president. And I had made a commitment to some friends that I was going to do that. And I'd had to go back on that commitment. So I did not pursue that in any regard. I think I'd had an excellent shot with Dad in the Senate, and of course, Alec Darnell's brother was in the House, but the other House member was closer to my father than he was to Riley, so I think I'd had a leg up on it. But in any event, I've never regretted not doing it.
Okay. Now,
I wouldn't take anything for the experience that I had.
Okay. We may combine this in a minute, but you have also been active in American Bar Association work.
Yeah. As you probably know, I finished my term as bar president in 1980, and the Monday after our bar convention, Joe Henry, who was a representative to the House of Delegates from the bar, dropped dead, and that created a vacancy for the House of Delegates. And I immediately got on the phone at a respectful time, got on the phone to the Board of Governors, basically my board, told them I would like to have that position. And they were kind enough to appoint me to fill out Joe's term. And then I held 4 terms. We had 4 seats, and I felt that I'd hold my seat for 4 years, and I voluntarily elected not to run again. And I mean, we've got people that's held it all longer than that, and I respect that, but my personal feeling was that there were other good lawyers that could have that and could profit from it and broaden out the base.
Now, the House of Delegates of the American Bar Association, explain that to us a little bit.
House of Delegates is the governing body of the American Bar Association. It's a little different from the House of Delegates we've got here in the state. Our Board of Governors is our ruling. The ABA Board of Governors is advisory, but the House of Delegates is the one that sets the board policy, sets the policy of it. And I had the privilege, they meet twice a year. They meet the annual meeting and the midwinter meeting. And I had the privilege of serving on that from actually 9 years. Joe Henry's 1 year, and it was really a fine experience. I enjoyed that very, very much. Then I had 6 years on the ABA Ethics Committee.
Right.
And went on that. That was an excellent experience. And one or 2 years on the committee on professionalism.
Okay.
I've sort of pulled in my horns on that. In the last 10 years, I've gone other directions, but I enjoyed that. That was a great situation.
I believe you were one of the charter members and perhaps were instrumental in the formation of the Tennessee Bar Foundation. Were you?
I was a charter member. I'll have to give Woody Sims full credit for being the moving force on that. We had a charter, but it had just been lying there dormant. And Woody just felt like it should be, and I give Woody the driving force on that. But I was privileged to be a charter member.
And you were later chairman of the
Yes, sir.
Board of Trustees. Okay.
One thing we got during our year, we got the court to adopt the opt-out rule
Okay.
on iota, which meant that IOLTA interest on lawyers' trust accounts, which was purely voluntary, but we had that going, and we did not have the participation that we should. The lawyers' trust money that's going to be in just in a rolling account, not money that's going to be in length of time, it had always been on a non-interest bearing basis. And after they began to pay interest on that, and Florida was the one that started that program, and they got it cleared through the IRS and all that. And the money would then come to the Bar Foundation for charitable work. Was not really taken in. It was money that really came from the banks.
Right.
The clients would never have had the money without it. It wasn't taking anything away from a client. It wasn't taking anything away from the lawyer. It was just, the lawyer sometimes, as you well know, is a little inert. It takes a moving force to make us move. And so some states had gone to mandatory. Some states had gone to, you would have to get in unless you option to get out. That's what we refer to opt out. And I could not see mandatory. I think later recent Supreme Court ruling has proved that we were wise in not going opt out. Not going mandatory, but went to opt out. And that gave, we went to the court and we petitioned them and met with them, Barry Bernstein, the director, and I, and explained to them what it was, how it worked. And as one justice says, well, who will pay the money? And I said, the banks. And that didn't exactly upset anybody.
Okay.
And it's been a great situation. And the lawyer has to either put his trust money, his or her trust money, in an IOLTA account where the interest is siphoned off to the foundation, or write a letter to the Chief Justice explaining why they don't want to do it. Well, it's a lot more trouble to write that letter than it is set up the account. And we were relying on that. Now, some that have opposition to it and have compunctions against it, they can still do that. We're not trying to force anybody in anything. And I think that the statistics show that a tremendous increase in the participation, and a lot of your lawyers just take it for granted you're supposed to do it. Now,
Right.
it's in a state of flux right now because the Supreme Court on a Texas case has held it's a state action unlawful taking, but Texas is a mandatory, it's a state bar, we're a voluntary bar, and they have a mandatory IOLTA, which I think could be distinguished, but that's other folks smarter than I are going to have to deal with that.
That's an area which we're very much concerned with.
We're very much concerned because that money goes to all sorts of pro bono work. It goes to our legal services, services to the poor, services to victims' rights, reconciliations. There's any number of good projects but the majority of it must go to legal services.
Yeah, Evans, as I indicated, I've known you for a long time, mostly through Bar Association work and various things, and I've always sort of looked up to you as
I'm taller than you, that's the reason.
as an ideal to try to pattern my career as far as ethics concerned.
Well, I appreciate it.
I believe most of your experience with the Tennessee Bar Association, the Tennessee Bar Foundation, American Bar Association House Delegate, and the Committee on Professionalism and everything has indicated that you have always been interested in legal ethics and professionalism. And I think that you think that is important to the legal.
I think that's the cornerstone. I think that is absolutely the cornerstone of being a lawyer. We have a tremendous amount of privilege, not right, but privilege, that goes with the license which we have. And with that privilege goes an equal amount of responsibility. And we catch clients in the most vulnerable of positions. If you're dealing with a person in an automobile accident, they're vulnerable. If you're dealing with a person in a criminal, they're vulnerable. Their families are vulnerable. Oh, Mr. Lawwell, get my boy out of this. I'll give you anything to get him out of this. When you're dealing with a person on an estate, they've lost the spouse. She's lost her lifelong mate. They're vulnerable. They in a never land. They don't know anything about the legal matters. And you can either complicate it for them or you can make it smooth for them. You can either do it for the money to rip them off, or you can. And I'm not adverse to getting reasonable compensation. I'll be the first to say that. The law has been very good to me financially. Not as rich as some, but not as poor as others. So that's all you can ask. But it's something. I see gouging going on today. It's outrageous. But the average person doesn't understand that. But if you're going to have the privilege of seeing a person's legal soul, and we do, you have got to be a high priest of the law.
In other words, you've got to have a different attitude than you would if you were an electrician or a mechanic
Or a used car salesman.
or a used car salesman. Now,
Although the used car salesmen have in some regards of their discipline is a higher standard than ours, because if they've been convicted of something, I don't believe they can get a license for 5 years, and we've been letting people get licensed in less than 5 years after convictions.
okay,
That's another sore subject with me, Ed.
all right. I don't know how long we want to dwell on this, but I do want to ask you if you have noticed any significant change in the legal profession in this regard over the last 50 years.
Yes, sir.
And what is that change?
Ed, I think, well, let me digress a minute, because you know me, I have to tell things in a convoluted way. But in my bar year, I made the statement that we were the last of the cottage industries. That was 79 to 80.
And what do you mean by that?
Well, the cottage industry, we were not part of a massive organization, but each person did their own thing, and we handmade it, and we served that constituency. Today, we're getting into a cookie cutter, mass production type of law practice, and the fees. And then the thing that really came out, several factors I think fell together. One, in about 78 to 79, when the Supreme Court in the Bates case said lawyer advertising could come out. Okay, Bates plus all its prodigy that's come on down to the point now that you can write a person a letter and do solicitations, as long as it's not in-person solicitation, has opened this thing up, and the lawyer, once again, I mean no disrespect to our U.S. Supreme Court, but they missed the boat on that. Once again, go back to the lawyer has the privilege. The lawyer has the privilege. With that privilege goes that responsibility, and you have to trade off. As a lawyer, when I put on that lawyer hat, I don't have all the rights I've got as a citizen. When I take that law, if I'm just being a citizen, I've got those rights. But I trade off for the privilege of being a lawyer. One of those was not doing that advertising, not doing that solicitation. The Supreme Court says, oh, it enlightens the public. It's not so. It's not so. It's a hucksterism. The advertisements you see, dramatizations and things, and they do tend to give unwarranted expectations of result. But statistics show they're effective. I have no objection to the yellow pages and a listing of activities, but beyond that, I just think it's very poor taste. I don't think it's professional. It's not in the interest of the client. It's to get the client in the door, it's to do a pocketbook-ectomy. And that's what it's looking for. That, combined with the Goldfarb case, which was a case that came up through Virginia Bar, where the Supreme Court knocked down minimum fee schedules.
Okay.
Now, I don't know about Columbia, but back before the Goldfarb case, Clarksville Bar would get together periodically, and we would
too.
set the minimum fee. We had a booklet, had it all printed out. The minimum became the maximum. The public knew what the standard fee was. The public could look and see, the minimum fee is this, and if I'm going to charge more than the minimum, I've got to explain to the client why this is more than a minimum case. Why this deed is more than a minimum case. What extra work did I have to do in the registrar's office? If this estate is more than a minimum fee, what peculiarities was in this estate? In this trial of this lawsuit, what was extra on that? They knocked that down, so now nobody knows. We still got in the rules of professional responsibility the criteria for setting a fee. Time spent is only one of the items. And our Supreme Court in the Hohenwald Bank case has reaffirmed those. But what do we do today? Everything's on a time basis. And what people fail to realize is that the timekeeping by the lawyer originally started out as a system of cost containment to see how much it cost me to handle this case. By figuring how much time I put, and then you'd back into it, did I make any money on it? Then they began to realize, well, I can set myself up what I want to make and how many hours I want to work, and I back into it.
Right.
You've got firms that put quotas on young lawyers. You must bill and collect so many hours. You've got firms, and frankly, I question that. You've got firms that will put out publications on how many hours this partner bills, how many partners this junior partner bills, how many hours this associate bills. They put them on the bulletin board. They make it a race out of it. So no incentive to get in and get out, do the value to the client. The longer you can churn him, the more stuff you can think to do. And then when they came along with unlimited discovery, and you can always, until somebody says, oh no, Hollis calf rope, I've had enough, you can keep on churning it forever.
How about expert witnesses?
I think, really, I disagree. I go back to the days when no witness could invade the province of the jury. And I think we made mistakes on that. That's a question of law. The courts and other people think anybody can express an opinion.
Do you know if the minimum fee schedules were fairly statewide?
I think they were. In fact, in 1972, the Tennessee Bar adopted a statewide minimum fee schedule. Right. It came out in a little red book, and it was right in line with what we've got. I've got some of those old 1956 fee schedules from Clarksville.
We had one in Murray County when I started practicing. We'd
periodically. What did you start at?
61.
Uh-huh.
We would periodically appoint a committee to look at it, upgrade it, be brought before the whole bar.
Yeah. Oh, and we'd print it up,
Okay.
and I think that then you put that in there with the, and of course most people just feel that the hourly rate is the whole criteria. And one question, when you talk about value billing and paying the lawyer more for the time it takes, and most people would, and a lot of alternative billings coming out now, they'll pay you to get it done quicker.
Right.
But the greatest analogy I know, would you rather pay a brain surgeon by the hour or by the job?
Right. Well, I think we've seen the pendulum swing too much in timekeeping, and it is beginning to swing back.
I hope it is, Ed. I really hope it is, because I think it is detrimental to the client. And you don't have to be a rocket scientist to sit down and look at a bill and tell, well, obviously this fell in the hands of somebody who had to make a quota.
Okay.
Now, I think the client's entitled to know what you do. And I think it's good practice, if you've got an individual client, invite that client to come to depositions to see if you're just fiddle-faddling or what. I think it's a good idea to correspond, give your clients copies of the correspondence. when you speak of doing memorandum of law and briefing matters, send them copies of pleadings, send them copies of interrogatories, send them copies of your briefs. If you got an appellate brief, send them the opponent's appellate. Keep them informed. Because when I was on the Board of Professional Responsibility, that was the #1 problem we had. The clients are not informed. The lawyer's doing a hell of a job, and he or she's on top of the case, but they haven't communicated with the client.
Right.
That returning phone call.
Of course, that's another area that I won't let you mention, but we won't get into is the profession policing itself. How do you feel that we're doing as far as policing ourselves?
I think that the Board of Professional Responsibility is doing a good job. I think, because I'm a little prejudiced, as I said, I had 6 years on it, and 2 years I chaired it, and Lance Bracey and his staff do a good job with what they have to work with. But lawyers will, and one of the early things in our rules is we shall report transgressions. But if you report somebody down in Columbia, and you'll become second only to Judas Iscariot. The other lawyers will, well, you came through with Ed Lawwell, he'll report you, no matter what you do. And I think that is something that the lawyer should be very much attuned to his and her duty to report these transgressions. I don't mean go on a witch hunt, but, and I've always had a policy, if someone comes to me with a transgression or perceived, I will help them, whether I think they're meritorious or not. I will help them fill it out to get it proper to send it in. Because if someone's going to file one against me, I would rather it be properly filed than shotgunned.
Right.
See what I mean?
Well, there has been a great improvement over the days when we were trying to handle them on a local matter.
Ed, I was on the Board of Governors when before the Board of Professional Responsibility was created. And we had the old so-called Rule 42 of the Supreme Court, which was the discipline, and it would come, and every Board of Governors meeting we'd close off in the afternoon, go into executive session, and fight this situation of whether or not we wanted to bring a complaint. And we always got into people's turf, and some folks that he's my friend, gosh, Ed Lawwell's a buddy of mine, I don't want to vote one on him, and all that sort of stuff. Then you had to get somebody volunteer to do it, and that was tough, and put a tremendous burden on the lawyer, and there'd be just a few that'd be really willing to do it, and we'd ride the good horse to death. And I'll be honest with you, I'd commented that the creation of the Board of Professional Responsibility and taking that off the Bar Association was a big factor in determining my willingness to seek the presidency. I didn't want that job, because then I'd been the hatchet man. Yeah. But we've been real fortunate in the staff we've had out there. They've not been quota seekers. They've not been out trying to, they've not tried to see how many people we can get and justify our numbers. The numbers come in, unfortunately, well enough without them seeking quotas.
Right.
But they take a sensible approach to it. And, digressing a bit, but back in the late 70s, early 80s, there was a strong move of the federal government to have the FTC take over and regulate the law practice. Right. And that was something that we had to fight during my tenure as president-elect and past president. That was during that same period. Of course, we settled out with a compromise that for the FTC to come in, they had to cross a threshold matter that the bar was not regulating itself efficiently. And that's all I ever asked, and then Senator Sasser and then Senator Gore in my correspondence, and Baker, but unfortunately Senator Baker never would respond to me, but that we would have a threshold question. The FTC had to determine that the particular bar discipline was not effective. I said, if we're not effective, then we ought to be taken over. But as long as we can be effective. But I do think but the glitch is there, is the reluctance of the lawyer.
Right.
Now, when I started practicing, probably when you started practicing, if I was getting on thin ice, one of the older members of the bar would pick up the phone, they'd call me, they'd say, Evans, have you thought about this? You fixing to step in a minefield or a bear trap. And I'd say, no, I hadn't, thank you very much. The older members of the bar would mentor the younger members, and the younger members would accept it. Now, the older members are still willing to mentor, but the younger members won't accept it. That's a big difference.
I believe this all gets back to the word that we've been talking about, and that is professionalism.
Mm-hmm. If we were a profession rather than a business, those that try to be professional will accept that. Those that see it as a business grab onto the profession. Well, I'm doing it for my client. But it doesn't require you to be unethical to represent your client.
Okay, that's what I wanted to point out. The conflicting forces here is the consumerism to be able to do it as quickly and as cheaply as possible.
And efficiently.
Right. And on the other hand, the lawyer has an obligation to look at the overall picture.
That's correct.
And make sure that what he's doing short term is not going to have a long term.
And you know, here's a conflict area along that same line that I think very few lawyers really see, and that is issue conflict.
Yes.
For example, if you represent a bank, I think you got a real problem if you go and sue another bank about a practice that bank is conducting. If your bank is conducting something very similar to that, you could set a precedent that could cut your own client's throat.
Right.
The average person sees conflict between the particular people, but they don't see the issue conflict. And that's an area that's growing in the legal ethics. You couldn't take one side of one proposition and a partner of yours take a completely unrelated,
Right.
and you couldn't take a position on an issue which might come back and bite an existing client of yours.
I'm going to ask one more question, then we'll take a break here and see, sort of summarize and see where we stand. But the question I want to ask you, and if you want to think about it after the break, it'd be all right. Where do you think we need to start in the organized bar of trying to instill greater professionalism?
Law schools.
Okay. How could we do that?
Well, there's one state, and this is sort of I'm glad you asked that. I hadn't set this up either. It's sort of been a bone in my throat. The requirements and the professional, personal information criteria for getting into law school is not near as stringent, and the questions aren't near as strict as the questions asked to take the bar. And I have tried for about the past 5 years, to no avail, to get law schools, particularly those in Tennessee, to take the same questionnaire that Board of Bar Examiners have and use that questionnaire to submit to each and every one of their prospective students. And I think it'd be fair to some of them say, "Oh, we're afraid of lawsuits," but I think it's fair to a kid to let him or her in law school, let them go 3 years of agony, and then come up and find out there's something in their background not going to let them take a bar. And that's just, if I was not going to be able to stand for the bar exam, I would sure want to know it before I went through that 3 years, not to say anything about the money that they're going to be spending. And you know, you can't teach ethics like you teach the IRS code. Really, you don't know where it needs to start. It needs to start with that 2 and 3 year old kid at mama's knee. And when you turn that, with all the juvenile problems we've got today, and the lack of parental control and lack of instilling of plain old common right and wrong, and that's what most of ethics are, just plain old right and wrong. How are you going to come along and instill it once a person becomes 23, 4 years old in law and becomes a lawyer?
Okay, we'll take a break at this point. Evans, we've been talking here for an hour and a half or so, and I want to conclude this pretty soon. A couple more questions I would like to get your opinions on. First of all, looking back over your 50 years of practice of law.
That sounds like a long time.
Right. What positive aspects have you observed, or can you tell us about?
Ed, I think one thing I think the continuing education program, I know when I first became active with the bar in the early 70s, we were having to try to sell it, urging people to come. And the mandatory CLE, I know it's not really probably the sole answer, but the lawyers, I think the lawyers are doing a better job of keeping up. There is more educational opportunity for the lawyer out there, and I think the lawyers realizing that. I think another thing that lawyers are more or less, whether they specialize or not, they're gravitating into areas, and they realize that the law is changing fast, and they try to keep, and I think there's an effort made to keep up. And one thing, let's face it, you're turning out a real bright group of young people. They screen them. Frankly, I think they screen them too much. I think they need to have some ordinary folks like you and me in there that can talk to ordinary folks, because everybody's not going to practice on Wall Street. We're going to be practicing in towns like Columbia and Clarksville. And I mean no disrespect to you when I say ordinary folks like you and me, Ed, but that's who we're dealing with.
Right.
And it's sort of like on one bar convention at the Vanderbilt alumni, they were bragging about all these high LSATs and grade point averages, and Harlan Dodson, a man whom I will always be beholden, says, "My God, who's going to deal with people? You got a bunch of eggheads." They will forget that. He says, "I couldn't get in."
I remember that.
You were there in Memphis, I think, in that one that had the silo type of, and he says, you've got to have people who can deal with people. Lawyers still tend too much, I think, to think they can do anything, but I think lawyers, if a lawyer could trust his or her colleague more, to say, Ed, I've got a client that needs a widget, I don't do widgets, you do, would you do it for him? And trust you to give them back to me.
Right.
Yeah. But yes, I think we've got a much higher caliber intellectual potential and educational level.
What about, and you're my generation, and I'm sure you haven't gotten in it too much, but have you seen the effect of the computer on the practice?
Oh yeah. I told somebody the other day, I wish they'd never invented the fax, because now they fax it to you, they expect a response back, an instantaneous situation. Right. But the whole thing is totally, you computerized law practice, you computerized research. I still like the books. I still like to read with a pencil and a yellow marker. Thank goodness they got the Xerox machines where you could Xerox out of the book, because I like to mark up the book. I'm a pencil writer. Daniel used to fuss at me all the time, but I can see you've been in here. You've underlined something. Don't underline in the books, boy. But yeah, I think there's a lot of positive. I think that the organized bar is trying harder to create the professionalism, but then you've got the dollar driven. And one thing, we've got to make lawyers go back and enjoy being lawyers. I had a lawyer at home tell me just this week, just about 3 weeks ago, that I and one other lawyer, the only two lawyers he knew at the whole Clarksville bar, that was practicing just because we really wanted to be doing it. And I think that's a shame. I think a lot of lawyers are not, I mean, you see the dropout. How many lawyers do you see today that say they're going to drop out, they're looking for other things, or they say, I'm waiting for the day when I can drop out and quit?
Okay.
And the lawyers always died at the desk.
What
In the old days.
role do you see the organized bar playing in the future of the legal profession and the increasing professionalism or awareness of professionalism?
It's sort of like, what role do you see the organized church increasing morality among the citizens? It's going to be a difficult situation. I would like to see more Bar Association contact with law students. I would like to see, I'm told that in law schools today, students are told, well, starting tomorrow morning when your classes start, you will no longer be friends, you'll be competitors. Because your high grades, your good paid jobs are going to go to that infinitesimal 1/10 of a point. You're going to be competitors. It's hard. I wish we could get the bar to work with the law schools to get that attitude out. It's awful hard to go 3 years in law school seeing every one of your classmates as a competitor, and then go out into the real world and see the other lawyers as colleagues.
I agree.
Now, when I went to law school, and I'm sure when you did too, you'd share anything you had with another lawyer, another law student. You'd study together. They'd say, Ed, I missed this. Did you get that? Can I borrow some of your notes? As I said earlier, it was like with the grace of God and a long-handled spoon, we all get through together.
Okay.
And this concept, and I hope this information I have is not prevalent, but I've heard it from too many sources, that they're teaching the competitiveness between the students. And when I've been told by young lawyers, when you realize that 1/10 of a point can, or 1/4 of a point on your average can be the difference in getting a $50,000 job and a $30,000 job, why should I help him?
Yeah.
But you're going to need him. You're going to need her in the future, and you're going to need a faith, the confidence, and the fair dealings. I do think that we need the organized bar to impress more the rules, and let them not be rules because they're rules, but because it's right to do.
Okay.
But I think it's awful hard. I like these creeds, but these creeds are just a creed, and they've got to come from the heart. The bar has got to target to make the professionalism, and you've got to target from the time the person enrolls as a law student, because they start being formed. The attitude towards the law, towards their colleagues, towards their fellow students, that those attitudes that are formed in law school are going to carry on when you get out in the firm.
Do you think it's a role that senior lawyers like you and I can play in instilling professionalism in the younger lawyers?
We could if they trust us. Now, we've had these senior counsel programs, and I don't know if you signed up for them, but you're not usually a young boy, but I've signed up for them in the past, and I feel like the Maytag repairman. Nobody calls. Occasionally, somebody will call and say, let me run this ethical matter by you. But unfortunately, there's a lack of faith and confidence and trust because of the competitive spirit. This group is no more competitive in the courtroom in advocacy than we were 40 years ago. But I think 40 years ago we were better able to leave that advocacy at the table, walk out, go to lunch, or if it's late in the evening, go have a beer, tell a few stories, and go home. And they can do today.
I don't know about you, but my experience is that occasionally when I do get asked questions from the younger lawyers, it's usually the ones that don't need it as bad as some of the others that don't call.
Though you're absolutely right. the lawyers who really need it the worst are those to whom no one can tell anything. And it's nice to be right, but it's even better to admit when you may be off base.
Okay.
I don't know about you, but I've learned more from the things that I got wrong than I've learned from the things I got right.
Right. Okay. We're not going to solve all the problems.
No, but we can try.
We can try it. And a few of us that can
One thing let me mention. I think the practice of law and trying to solve these problems are going to have to come about like a friend of mine told me a number of years ago, who was a defensive tackle for the coach down at Clemson. He said the coach told him if he stand up and hold his arms out as far as they could go and swing around and make a circle, and if he could control everything in that circle, he could play defensive tackle for him. If we can control everything in that circle immediately around us and get others to try to do the same, Ed, we can start it back.
Okay. Very good. Let me just conclude by asking you how you would like to be remembered.
Well, I'm not in any rush for that to happen. But I'd like to be remembered as a lawyer who tried to make things better. I'd like to be remembered as a lawyer who really put his clients first and who cared. And I don't mean that job, I don't mean the old joke about the tombstone that says, "Here lies a lawyer and an honest man." That I didn't know you could bury two people in the same grave. I don't mean that at all. But I would like to be remembered as someone who dealt with people on a fairly. I said earlier, I think we are the high priest of the law, and anytime we cease to take the feelings of a high priest of the law, then we're denigrating our profession. But I would like to be remembered as someone who tried to make things a little bit better, not only for myself, but for those around me and those to come.
Very good. We will close on that.
Thank you.
Thank you very much, Evan.